record this. Some folks wanted to hear this after the fact. So yeah, back to your question, we can provide slides to you after this. We can also provide this recording. So if you missed something or you have a bad connection or whatever it is, you can revisit it. So
that's great. Thank you. I'm sure it's gonna be a great resource. Thank you.
And feel free to pass it along to others if you'd like. So all right. So again, folks have a constitutional right for due process. And so that's really the underlying thing here. People have under the US Constitution, it says no person shall be deprived life, liberty, or property without due process of law. And that's part of really what we're talking about here is, when it comes to land use law, people have rights. And so, running an efficient meeting and hearing is really part of that. And so, we want to just impart the importance of that right off the bat. And we're going to talk about some of this stuff. And again, some slides I might go over a little more quickly than others. If you have questions, feel free, like John did, just chime in. Let me know if you want to stop or you have questions for more information. So there's different types of meetings here. There's the basic meeting, which is sort of, let's say, the regular planning commission meeting of Cavendish or Chester. So you have, generally speaking, a regular meeting schedule once a month, maybe twice a month. Those are your, regular meetings, and you can have special meetings. Meetings are generally where a quorum of the board gets together and they discuss business, they take action, they make decisions. Those are the meetings. Who does it? All public bodies. So that's the planning commission, select board, cemetery commission, you name it. All of those have these meetings. There's also a thing called legislative hearings, and that's sort of, moving from left to right. They sort of get a little more rigorous, a little more formal as you go. Legislative hearings is where somebody's coming in. Legislative hearings are where basically a town is adopting either a town plan or zoning or flood bylaws or something like that, and they have to have a hearing before the adoption process, as part of that adoption process. So that's really what that's all about. In this context, the planning commission usually has the first hearing. Hey, here's our draft enhanced energy plan. Is there any comments on it? And then, then the planning commission closes the hearing. They vote to pass it forward to the select board for adoption. The select board then has a hearing, and then, they close the hearing. Then they can vote to adopt the thing, whether it's the plan, whether it's zoning, something like that. Then there's quasi-judicial hearings, and that's kind of like a quasi-court type situation. This is where an applicant has come forward and they say, I want to build a house or an apartment complex or whatever. They've issued or they've given the zoning administrator an application. It's complete. A hearing is scheduled, and they're coming before the development review board or the zoning board or planning commission in some cases for approval. And so those are a little more rigorous process. In most towns, that's a development review board. Again, some towns have a dual role where the planning commission maybe approves subdivisions and the zoning board approves other things. And it can be a combination like that. And in Cavendish, you probably don't have a ton of these. Maybe you have something for flood hazard projects. I'm not sure. Other than that, you probably don't have too many quasi-judicial hearings because you do not have zoning. So you need to have public notice for all of these things. Again, the whole spirit of this is people need to know when this stuff is happening, where they can go to understand what the decision-making process is and learn what's going on and chime in on it. So for meetings, and for regular meetings, the reference there, 1 VSA section 310 and so forth. That's the open meeting law section, and we'll talk more about that later. Under that, you're required to do these notices. So for meetings, you got to notice it 48 hours, basically 2 days in advance. And you got to post the notice in 2 or other places, or in the town office usually, and 2 other places. Legislative hearings, usually those are, again, that's for a plan or a bylaw amendment. And when I say bylaw, talking regulation, ordinance, ordinance in a loose sense, zoning ordinances, flood hazard ordinances, bylaws, is basically the same term. Bylaw is the term of art in statute, but some people refer to it as regulations or sometimes ordinances. For legislative hearings, that takes a 15-day notice. And, you have to have an ad in the paper. You have to have some certified mailing. So there's some extra stuff you got to do for the notice there. And then in a quasi judicial hearing, kind of even more rigorous. So this is for some kind of a development review procedure. The notice is either 7 days for things like site plan review, or it's 15 days for conditional use review, final subdivision, that kind of thing. Your zoning document will tell you what the day period, what that notice period should be. Again, you're putting the ad in the newspaper, you're posting it in 3 or more public places. You're saying it, making sure that the applicant and the adjoiners get copies of it, and all that stuff. You got to follow all of those details for quasi judicial hearings. And so, may not happen a lot for some of you, but when you have one of these quasi judicial hearings, again, this is for development review situations, the role of the chair is really important in these. The rules are a little stricter, and it's really the chair's job in these cases to make sure, it runs smoothly and people, have that ability to participate, but also that you don't want comments to go on and on and on forever. And you just try to have this nice, as smooth as you can process. Usually the chair opens the hearing and then allows the applicant to present the proposal. After that happens, the board members are then given an opportunity to ask questions of the applicant. Then anyone else who's in the audience is then given the opportunity to comment or provide testimony. Once all that's done, the hearing can be closed. The big thing there is making sure you have enough information before the hearing gets closed. Once it's closed, you only have 45 days to make a decision. So you really want to try to make sure you have as much information as you need before the hearing's closed. Sometimes you might want to continue the hearing till the next meeting, the next month, so you can kind of get more information and make sure you have everything that you need. Okay, so there's a couple of things here that you should make sure that you have during these particularly fussy judicial hearings. You want to just make sure you have a really clear order of events. This is how it's going to proceed tonight. You want to have, most boards are supposed to have these rules of procedure and ethics policies, so you'd want to make copies of them available just in case people in the audience or the applicant or somebody needs to be aware of that, and to have the board members make sure that they have it in front of them. For you new board members, if you don't know what this is, you should ask your chair or your zoning administrator, hey, what is this rules of procedure thing? Let me get a copy, would you? And then again, this is usually what the chair's doing during the hearing. They often would review what a quote unquote interested person is, and they would administer an oath for those people, and anyone who wants to testify during the hearing. And then there's also hey, does anyone have any conflicts or ex parte communications they need to disclose? And that's also something that the chair asks every time, or should ask every time. And we'll talk a little bit more about what that really is. So again, kind of rehashing, but the role of the board chair is really just to keep to the agenda, keep the board members focused, stay on target, and basically get to the end where you can make a good decision. Essentially, smooth process. So the board members, so if you're not the chair, what's your role? Basically, it's to listen, it's to ask questions, it's to make sure that the project meets the rules. Your job is to look at what the standards are and not go beyond that, generally speaking. You want to avoid conflicts of interest. So for example, if you have some kind of a financial arrangement, or you're related to the person applying for a project, you're best to not participate. You want to base the decision on evidence that was presented, not just kind of the rumor floating around town, anything like that. It needs to be fact-based. And also, you shouldn't be prejudging these things. Yeah, I'll leave it at that. So after that quasi-judicial hearing is closed, the board then enters a deliberative session. Some towns do that in public. Most do it in private. So what usually happens, you close the hearing, basically you kick everybody out, or they leave anyway. And then it's just the members left, and they can kind of go through what they just heard and clarify what their decision is and how they should write it up. All decisions need to be written, and so that's what they're basically doing in the deliberative session, is going through the details so they can write that decision out. They have 45 days in which to prepare that thing. If day 46, basically it's deemed approval. So if you fail to have a decision in that time frame, it's deemed approved. And there's always a question of, how do you know? How do you know? So usually we've had attorneys tell us, the applicant should really appeal at that point. On day 46, there really should be an appeal. That way there's a paper record that it's deemed approved. Otherwise, how does anyone know? But honestly, that's one for lawyers to fight over, to be totally honest with you. So conflicts of interest, this could be like what I mentioned before, financial interest. So let's say I've donated money to the Friends of the General Store, and the general store is applying for whatever edition. I probably then, if I'm on that board, I should recuse myself. I might have a financial interest in that. Maybe my sister owns the general store and she comes in for an application. Again, I should probably not participate. If there's question, or if there's literally not enough people on the board, if I recuse myself, often what's good is hey, listen, I would ask my fellow board members, listen, this is the situation. My sister owns it. I think I should recuse myself. What do you think? And let your fellow board members tell you, no, I think it's okay. I think it's okay. Or no, you really should recuse yourself. Half the time disclosure is the biggest thing. But if you're not sure, let your fellow board members tell you what they think. And if there's known bias or prejudice, for example, let's say I've really this big outspoken opponent of Walmart or whatever, and Walmart comes to town with a proposal. I really shouldn't be part of that decision-making process because I've already established I don't like it, right? So that kind of thing. Be careful of that. And then ex parte communication. So, you're on the board, you're getting this application for whatever apartment complex, and people are talking to you in the grocery store. Boy, I really hate that project. It's gonna just be the worst thing ever. And you should, number one, you should try to avoid those situations because you don't want to prejudge an application. But if it happens, because it does happen sometimes, you disclose it. At the hearing, you say, listen, so and so approached me. I was trying not to talk about it. What do I do? The biggest thing is just to lay it out there. Everyone knows. So you just want to disclose in most cases that happened. And the note at the bottom, it really is true. All it takes is one goof up, and all of a sudden your board has a terrible reputation for years. So, it is good to just kind of keep the reputation of the board intact by doing these sorts of things. Okay, so again, how do you deal with conflicts of interest? So you should have some kind of rules of procedure and ethics. So you should know them, you should follow them. Ex parte communication, it can happen. Don't freak out over it, but disclose it. Like, hey, I got an email from such and such, and I didn't do anything about it, but I got it. So here, just tell the other board members about any kind of that type of communication that happens. And recuse yourself when necessary. That's why we have alternates. We don't always have them actual people filling the alternate positions, but that's why we have them, is that they can fill your shoes when you have to recuse yourself for some reason. So again, this is really about open meeting law and really ultimately about due process, people's constitutional due process rights. So, it's really important. You got to give that proper notice. This meeting is happening. This hearing is happening. This is what we're going to be deciding. You need to make that pretty clear. We're going to talk a little bit more about that next in the sort of the open meeting law stuff. But you're then running the meeting or the hearing in a good way, in an orderly way, and giving people a chance to be heard. And ultimately, you want to have a good decision-making process. So you're taking in the facts, you're making good decisions based on those facts. It's not always easy, but that's the goal. And again, you're trying to manage it so that there aren't conflicts of interest or other things like that really kind of undermine the process. So there are some resources. They're getting a little older now, but if you go to this vpic.info website, there's quite a lot of information on there. There's a zoning administrator handbook. There's this essentials guide. There's plan and bylaw adoption tools. There's model rules of procedure. There's a whole bunch of other stuff on there too that I think is, it's old. Frankly, all of it's getting a little old, but it's still mostly helpful. There is an effort to figure out how to update some of these things over time, but it takes time and money, and it's likely going to take a bunch of time to update them in a real way. I'm going to pause. Are there any questions on that at this point?
No, I'm good. Nice job.
Okay, so we're going to segue into really a similar conversation, but open meeting law. We're going to talk a little bit more specifically about open meeting law, and there's some temporary rules that kind of relax a few things, and we're going to talk a little bit about that. So again, a lot of these slides have too many words on them. They're probably best as a future reference, not so much for a presentation, to be honest with you. So I'm going to try to skip around and paraphrase and this and that, but again, we'll provide these slides to you later, and I hope they're helpful. The open meeting law, the statutory reference is there at the top. If you want to go and look it up, you certainly can. Honestly, I'd encourage you to go to either the Secretary of State's website or Vermont League of Cities and Towns, vlct.org. And both of them have really good information and like frequently asked questions and stuff like that. Probably those are far more helpful for you on open meeting law than this. But anyway, that's where you can find the law. Basically, it's a government transparency and accountability thing. And that's really what this is all about. All meetings of public bodies need to be open to the public. There's a few exceptions to that, like executive session, but generally speaking, they all need to be open to the public, and it requires, advanced public notice. Most to all decisions are made in public meeting. There are a few exceptions, and then it allows members of the public to be there. They're listening to the sausage making, the decision making process, and they're able to participate, ask questions, and that sort of thing. That's really what it's all about. And you also need to take minutes. You have to have a sort of a summary of at least a basic summary of what happened. When did it happen? Who was there? What was the decision or decisions that got made? So what's a public body? Pretty much it's any board of a town, for example. I mean, it's definitely the planning commission, definitely the zoning board, definitely the development review board. Some towns decide to have more of an ad hoc group that might do certain things. And in some cases, they decide to do that. So it's just sort of not under the select board's purview, honestly, sometimes. Other times they do it because, it's a little easier. Maybe you don't need to follow open meeting law, and they're not the government. They're just a group of people doing stuff. And so that's not a public body. I guess that's where I was going with, but if it's official committee or commission with appointed members from the select board and that sort of thing, it's a public body and you're supposed to follow open meeting. And so what's a meeting? Really, it's anytime there's a quorum. So if you're, going to the, concert on the green in Proctorsville and all of a sudden there's a quorum of planning commission members, technically that's a meeting, right? So you just don't discuss business in that situation. But every time else you gather a quorum deliberately, then, you need an agenda and all that kind of stuff. And yeah, part of it is it's easy, I should say, to get caught up in email conversations or something, even text, group messaging and things like this. Those could be considered meetings. If there's a quorum of the board involved and there's doing other things beyond setting a meeting date or things like that, honestly, you're probably making some decisions and that's really not ideal. If it happens, whoops, you can disclose it at the next meeting, but you try to avoid those sorts of things. So there's generally 3 types of meetings. There's the regular meeting. We meet the first Wednesday of every month and, at this time, at this place. Those are the regular meetings. Those take an agenda posting in 48 hours advance notice, if not more. Special meetings, something comes up in between the regular meetings, you got to meet for whatever reason. That's a 24-hour notice. So it's quicker, half the time, basically. You got to have the agenda up a good 24 hours in advance. And emergency meetings are, only when really, really necessary. And frankly, I don't know when I've ever seen one. But you're supposed to give public notice as soon as possible. And I don't know, again, I've never seen an emergency meeting. They could happen, but in a planning context, they're pretty rare. So the agendas, you got to post them usually in the town office or near it, and then in 2 other places, maybe the library, maybe the post office, maybe the general store, maybe the message board, along the road as you enter town, those sorts of things. And then if you have a website, it should be posted there too. The content, the time, the place, the location, or if it's a conference call, the phone number. If it's a Zoom link or something like that, you need to have the hyperlink on there so that people can access it. You need to have basically what are the topics that are going to be talked about. It shouldn't just be old business, new business, and then all of a sudden you're approving a zoning update or something like that. It really should say zoning update. It shouldn't be vague. People should have a pretty good idea of what's going to be talked about. And at the beginning of the agenda, there should be like a changes to the agenda type of that really should be like the first thing you do. You might table something to the next meeting. You might potentially add things. You might shuffle things around. My caution with adding stuff is, again, you wouldn't want to like all of a sudden add zoning updates and all, like slip through some big meaningful change on something without people knowing. So I don't really think you should make decisions on new things, but maybe there's an update that's needed, or maybe things like that are totally fine. So at the bottom, temporary changes. So since the pandemic started, there's been a relaxation of some of the requirements. So you can have conference calling, meeting by conference call, or through Zoom. It could be totally remote, right? So everybody, it could be on Zoom. If so, you got to be clear about that and then provide that the information so anybody can log in. And at this point, we're able to do that for a while longer. We'll talk a little bit more about that. So at the end of each meeting, you got to have some minutes, and at some towns it's like a court transcript. It does not need to be that detailed by any means, but it could be at a basic level. Who was it, who met, where, when, who was there, what were the decisions made. You'd want to have, so-and-so made the motion, so-and-so seconded it, and then all in favor, that type of thing. I personally like to have a little more information about it. Like, we decided that Joe was going to bring the draft zoning map to the next meeting, or, some key takeaways. I like to add that kind of thing in there, but that's up to you. Minutes are supposed to be, now this is draft minutes we're talking about. Draft minutes need to be available within 5 calendar days. They should be posted on town. If you have a website, they should be posted on the town website within 5 calendar days. So that can sometimes be hard, but that is the requirement. There's not a 5-day police, but some people might call you on it. And that is the goal, is to get them up there within 5 days. And you maintain them for a year. So I'm probably going to skip through executive session a little bit, but I'll pause on this. I'll talk a little bit about this, but I may skip through the next couple slides. Executive session's pretty rare for planning commissions and DRBs and stuff like that. It doesn't happen a whole lot. Executive session's a lot more common with a select board or something like that, where they have personnel issues they need to deal with, or legal counsel's there. A DRB might have a situation where they go into executive session because their lawyer is giving them advice about a development. It happens. Planning commission might go into executive session if they need to talk about, let's say, they recommend the zoning administrator to the select board, who then appoints them. So if there, let's say there's an issue with the zoning administrator, they might do that in executive session, so they don't embarrass anybody or whatever publicly. But these are pretty rare. There should be a topic on the agenda though. So usually it's at the end of the agenda. Go into executive session for personnel matters or for legal counsel. It doesn't have to be super specific, but there needs to be some indication of what it is. And you're supposed to talk about a provisional law. You talk about, all this kind of stuff. If you're in a hybrid environment, basically you could pick everyone out, put them in a waiting room. It gets a little harder in the virtual or hybrid meeting setting. But again, I think it's so rare generally for us that I'm not going to dwell on it too much. You just want to have a system in place to make that work well. And deliberative sessions are not executive session. Those are two distinct things. Again, I'm gonna skip over this. This has a little more detail for your future reference, but these are the types of situations where maybe a board would go into executive session. Again, I'm going to kind of skip over that unless there's questions. So this little picture might look familiar. We've been in this world of kind of electronic or hybrid meetings for a while. Open meeting law allows it without the pandemic temporary changes. It's allowed, but you need to have a physical location so the public can access it. So, you have a Zoom link, but the agenda, states, the meeting is also in the town offices. And so, in ordinary situation, you'd need to have that. And, it gets a little funky in that, well, we'll talk a little bit more about it, but you want to make sure that people can really hear and participate. With the temporary changes though, you don't need a physical location. It could be exclusively Zoom link or a conference call, phone number. But you do need to record it. And there might be some differences between the select board versus the planning commission, this and that. But generally speaking, you should record it. It's easy nowadays. So it makes a good record of the decision making. Key thing is, sometimes the quality is so bad that it doesn't really work. And so, if the technology is not really working, the meeting's not really working. And so you need to be able to hear each other in order to make good decisions. So, if it's not working, you probably should cancel that meeting, close it, and try again and work out the technology issue for the next time. There's a lot of concern about people like hacking into the Zoom meeting. I've never had it happen. There are some safety features, I guess you should familiarize yourself with some of that. It's never happened. Unlike tonight, it's good to have a moderator so that like if somebody's trying to enter and I don't see it, somebody else is there to let them in, or if there's some chat conversations going on, it is nice to have a second person there to kind of help out. And again, it's always nice to designate somebody to help with those sorts of access problems. I can't get in, the link's not working for me, it's good to do that. We goofed up the other day. We had a meeting across the street in the town office, and somebody the Zoom link was not working. At the bottom of the agenda, it said contact Lisa for if there's a problem. Well, Lisa was in our meeting across the street. So nobody could get a hold of her. So don't do what we did. Think about a better option so that there really is a meaningful way to kind of work those kinks out. So again, the whole idea is, open, transparent meeting process. So, if you're having an electronic or a hybrid meeting, you want to have those agendas available, more than, ideally more than 48 days in advance, or 48 hours in advance. The more notification, the better. You want to be able to have all of this other stuff in place. Again, the whole idea is really just to have good access to the information, so folks understand how the decisions are made and have an ability to kind of participate. So what happens if you don't have your minutes within 5 days and all this stuff? Basically no one calls us on it when we goof that up, but somebody could. And if they do, say, oh, my bad, we'll respond. We'll get you those minutes within, I guess, 10 days is the requirement. But as soon as you can, here are the minutes. Sorry, I didn't have them on the website. Here you go. You try to cure the situation the best you can. And then you may want to figure out, how do we avoid that in the future? There are cases where maybe the public body denies that, no, we had it, it just, you couldn't find it. It's on our website here. And, it could be something like that, I suppose. Or you just don't respond to a complaint. And that's basically the same thing as a denial. So a citizen can file suit, and there can be a misdemeanor fine and so forth and so on. So it could result in that, but I've never heard of it happening, but it could happen. So there was this Act 1, the first act of this session, extended this temporary measure of allowing fully electronic meetings and that sort of thing. So we have through July of 2024, sort of in that completely virtual environment. So if you don't want to meet in person, you don't have to. But I think most people are happy to go back to in person, or at least a hybrid situation. And these are those things that you have to be thinking about. Technology. A lot of towns have pretty decent technology now, but if you don't have technology to make it work, let's say you have really bad broadband, then it's probably not going to work. So you should stick to the in-person thing. You should be recording the meetings. And again, it's saying legislative body and school board, but I think all boards should probably, if it's in this like a Zoom situation where it's easy to record it, I think you should record it. I think that would be ideal. Again, you just want to make sure that people can hear and be heard and make decisions, and everyone's participating. Okay, so Vermont public record requirements. So this is kind of summing things up here. I think we're getting to the end. It applies to all public agencies. So unless you have an ad hoc group or whatever, if you're a town board, this applies to you. Public records, they're open to the public. The public can ask, show me the minutes, and they should be available. They have the right to inspect it. They want copies. They have a right to all that stuff. You do need to keep the records at least for a year. They said a year. I'd keep them longer, to be honest with you, especially if it's involving town plan adoptions and things like this. But it applies to paper and electronic records. So again, you should be keeping these records and maintaining them and making them available to the public, at least when they ask for it. And if you do have a town website, the agendas and minutes should be up there for at least a year. Okay. I think that was it. I didn't mean to close my presentation mode, but that's basically it. So if there are questions, I'm happy to, or observations, or maybe I said something you disagree with and you want to talk about that. That's okay. Any questions or anything like that you'd like to bring up?
Yeah, Jason.
Yep.
The role of the chairman or the chair, as I understand it, it's to obviously run the meeting, but can they make a tie-breaking vote? Is that their role?
They can. Yep, that's right.
Okay.
Different chairs do things a little bit differently, but I generally am of the mind you don't. You're primarily the facilitator. You're making the meeting run well. Um, you're calling for the motions and the seconds and making sure people understand what they're voting on and all that kind of stuff. Often the chair doesn't need to vote, but if there is a tie, yes, that is your role. I'm not saying you can't vote, but I generally like to not if I'm the chair personally, but anything else?
I want to thank you for doing this. It's helpful to get started like this and have somewhere to go to find out the rules and regulations. So I appreciate it.
Yeah, I do as well. Very well done. Thank you. Thanks for your time.
Well, thanks. I was worried it was going to be too boring, but nobody's asleep yet, so I guess that's good.
Thank you very much. Really
Jason.
appreciate it.
Can you hear me yet, Jason?
Yes. Yep.
Oh, you can? Oh, good. One thing that I found helpful that I don't think you mentioned was kind of an administrative thing. When you have a hearing, if you can take attendance, and I used to do it by passing around a sign-up sheet and have people write down their name and address, because it's not that unusual where you end up having to send a decision out to someone if they participated in the hearing. So it's very handy to know who they are and where they live and where you should send that.
Yeah, I think that good catch. That was in the presentation. I skipped over it, I think. So yeah, thank you for pointing that out.
Another thing, if I can just throw it out there, is I've witnessed so many development review boards and zoning boards. They want to be open, and so they have a tendency to want to make decisions in open session as soon as the hearing is closed. And the decisions are always better when they don't do that. If they go into a private session and they take the time to talk about everything that they heard and weigh the evidence, that comes out much better. I've seen boards close hearings and say, okay, what do you think? Someone makes a motion to approve it, and nobody knows when that happens, well, what evidence did they find compelling, and how did they weigh that against the regulations? So I always felt that was really, really much better to go into a deliberative session prior to making a decision.
Yeah, and I like I echo that. I think private deliberations are really good. Others will argue, we should do it in open session, but let's face it, members of planning commissions and development review boards that are volunteers for the most part. They're not experts in this stuff. And it's awfully nice to be in a private session where you're not afraid to ask a dumb question. It's good. I think it's good to be in a sort of a closed environment to kind of, it can be messy sometimes to, does that project really meet all these standards? What does this standard mean? You don't really want to do that sometimes in a public session. So yeah, thanks, Martha. I agree. That's good points. Anything else? So let's see, I'm gonna follow up with you all so that we have a survey that we'd like to ask you to just let us know if this was helpful or not, and if you have thoughts for a future training. And then we'll share the slides, and if you really want, we'll also share the recording, so you can really do this twice if you really want to. So, but I'll pause again to see if there's any other questions before we close it out. Anything else?
Just wanted to say thank you very much. Appreciate your time. It's great.
All right. Well, thanks, everybody. It's
Thank you,
really
Jesse.
nice outside. Thanks for sticking with me on Zoom here for an hour or so. And I hope it was helpful.
Great.
Very good.
Thanks,
Have a great
Jason.
night. Thank you.
Yep.
Everybody.